to have been living under a rock not to have seen how sexy employment law got this year. Truly sexy, about as sexy as employment law can ever get, which isn't very sexy. The sexiest it got actually was the national headlines, and you probably know what we're going to start this section of the talk on, and it is the string of cases that were looking at that fairly knotty issue about holiday pay and overtime. As I said, that's about as sexy as it gets. But the media did really get stuck into a bit of a frenzy, and they ended up churning out various doomsday scenarios for employers, speculating about how many businesses were likely to go bust as a consequence.
I have to say, for a while it did look pretty bleak. This has been a hot topic actually for quite a few years now. It's been bubbling under and it's getting hotter and hotter. And there's part of the problem is the difference between UK and European law on holiday pay. There's the EU Working Time Directive, which states that workers have the right to at least 4 weeks paid holiday per year. But it doesn't say how holiday pay needs to be calculated. 3 years ago, the European Court of Justice ruled that the European Directive actually required holiday pay to be based on what was called normal remuneration, whatever that means. Well, we're going to find out a bit more in a minute. And that should include payments which are linked intrinsically to the performance of the worker's tasks. So we don't need to say anymore, it's so obvious, isn't it? That's the answer. Now, that particular case of the ECJ was brought by pilots who said that their flight allowances should be included, even though they were obviously not earning them when they were on holiday and not flying. The decision actually was that holiday pay would have to include for pilots both their normal pay and their flight allowances.
And the European directive is implemented here by our working time regulations. And under those, UK workers are entitled to 5.6 weeks annual leave rather than the minimum 4. Now, under our regulations, that holiday is paid in line with the rules on calculating a week's pay, which are set out in the Employment Rights Act. And under those rules, workers who earn a basic salary plus commission are entitled to holiday pay based on their basic salary alone.
So there's the conflict. Commission payments, bonus payments and overtime payments are all intrinsically linked to the worker's job. So on that basis, applying the European Court's version of events, holiday pay was not being calculated correctly and workers were being shortchanged. And this led to a string of cases where our tribunals and appeal courts had to interpret our working time regulations to make sure that they did give effect to the European directive as interpreted by the European Court. So the first important decision on the issue last year was in Locke and British Gas Trading. And you've got to listen carefully to this one in a way. Mr. Locke, he was an energy salesman for British Gas. He was paid a basic salary and sales commission on a monthly basis, and his sales commission made up around 60% of his remuneration. And when he took 2 weeks annual leave in December 2012, so quite a recent case, he was paid his basic salary and also received commission from previous sales that fell due during that period.
But obviously, Mr. Locke didn't generate any new sales whilst he was on holiday, which meant in the period afterwards he suffered a loss in pay because his commissions went down. And so he brought an employment tribunal claim, and he said that that amounted to a breach of the working time regulations. And the tribunal hearing that claim referred it to the European Court of Justice because they wanted a definitive ruling on how holiday pay should be calculated in those circumstances.
And they applied this principle of normal remuneration, and the European Court of Justice decided that Mr. Locke's sales commission was directly and intrinsically linked to his employment as a salesperson. That bit's easy. But that under the European directive, this meant that the commission that he couldn't earn while he was on holiday, because he was not working, must nonetheless be taken into account in calculating his statutory holiday pay.
So the European Court accepted that he received commission while he was on annual leave, and that the financial disadvantage occurred as a result of his inability to generate commissions during the holiday period, which then didn't take effect until a few weeks afterwards. But nonetheless, they said that that was still contrary to the objectives of the directive because the worker might be deterred from actually taking annual leave.
It's a somewhat challenging case, I think, but he was entitled to receive additional sums by way of holiday pay to represent commission that he hadn't actually earned by selling anything while he was on holiday, but that he notionally would have earned if he hadn't been on holiday. That's the decision. And it was left then, the mechanics, which are the hard bit, were left for our tribunals and courts to assess how on earth those payments should be calculated.
It's madness, isn't it? Absolute madness. So clearly a very unhelpful decision for employers. But it also opened a can of worms because there are a lot of unanswered questions that flowed from that particular decision. I mean, in Mr. Locke's case, the commission was a contractual entitlement, but other payments are directly linked to a worker's tasks. Overtime is an obvious example. But what happens if you're not actually obliged to work overtime? It's voluntary. So you do it if you feel like it. Are you entitled to have your holiday pay increased in those circumstances? And there are also other payments that are regularly paid. So attendance bonuses, travel allowances, do they have to be factored in? And another question was, well, does this apply to the full 5.6 weeks of holiday entitlement under our regulations, or is it just the 4 under the European directive? And the big one, and this is the one that hit the press, how far back could claims for arrears go? Would it be 6 years, or could it go all the way back to 1998 when our regulations came in?
And I'm sure you'll remember last year when it suddenly hit the news on the radio, the TV, the papers, the internet, etc. It was a combination of all those rulings and the fear of the arrears claims going back 6 or indeed more than 6 years that sparked all those newspaper headlines, etc. And based on 3 particular appeal cases that came before the EAT, they covered almost all of these issues, and they were collectively known as the Bear Scotland Trilogy. It makes it sound right. Well, yes, Bourne Trilogy, nothing on this.
I mean, we obviously haven't got time to go into the outcomes of each of the 3 cases, but we'll try and give you an executive summary of where the EAT got to. The EAT decided that in light of European case law, payments in respect of non-guaranteed overtime, which were made with a sufficient degree of regularity, would have to form part of a worker's normal remuneration. So that would have to be taken into account in calculating holiday pay under the European directive. And the EAT also decided that the taxable element of travel allowances received by workers was directly linked to the work that they performed. So again, they would also have to be taken into account.
Now, the EAT did decide something going the other way. They said that all these additional elements that now have to be factored into holiday pay only apply to the minimum 4 weeks that are required by the European directive. So the additional 1.6 weeks, which was to equate to the 8 days bank holidays, if you remember, that are provided for under our working time regulations, they can carry on being calculated in accordance with our working time regulations, because only the 4 weeks need to be consistent with the European law.
Now, one of those 3 cases did deal with voluntary overtime, but it actually settled before it got to the EAT, so we didn't get a definitive ruling on whether voluntary overtime also falls into this sort of new regime where the pay is increased to take that into account when holiday is taken for the 4-week period. But if you look at the other European decisions, I think it's clear that the idea is that workers shouldn't be put off taking their holiday leave if that is likely to result in a loss of pay. So if voluntary overtime has been worked regularly, then we think the likelihood is that you are going to have to factor that into the calculation for 4 weeks of the worker's holiday entitlement.
And there are, unfortunately, some other unanswered questions at the moment, including how you calculate the pay if commissions or other payments indeed fluctuate. Averaging payments out over a 12-week period, the 12-week period prior to the person taking their holiday, which is tedious and a hassle, but is known to be acceptable generally if you can do it, but even that might not actually be permissible if it disadvantages workers, because averaging out over a longer period would actually produce a more representative figure. And that's an issue which comes out of that Locke case on commission, of course.
And the big question, well, how far back can arrears claims go? It was certainly arguable that they would go back 6 years, marginally arguable that it could go back to 1998. And again, this is what really hit the headlines, because you may have seen in the papers that it was off the back of the Locke decision that the John Lewis Partnership decided to pay 6 years worth of arrears to each and every one of their workers, and that cost them a reported £40 million.
However, the EAT's decision did do one other thing, which was very much intended to limit the damage and limit the scope for retrospective backdated holiday pay claims, which would have to be based on what we call a series of unlawful deductions from pay. And this was a pioneering new development by the EAT at the time, which decided that a gap of more than 3 months between unlawful deductions would break that chain and prevent the individual from going back beyond that. Now, the EAT granted leave to appeal their decision on this point, knowing that it broke new ground, but actually Unite has decided not to pursue that appeal. So the law is going to stay there until somebody else raises it again. So at the moment, it is likely that you would be able to rely on that if somebody's trying to claim holiday pay going back to time immemorial. It's also likely that the first 4 weeks of any holiday in any leave year can be attributed by you to the 4 weeks that the directive requires, so that any miscalculations that historically that you now realise you've made beyond that in a leave year could be said to be not unlawful, remembering that it only applies to the 4 weeks. So once a person's got their 4 weeks out of the way, any extra holiday that they've taken are arguably not in breach of anything. You've calculated it in the correct way. So because of those two factors, and the fact that people frequently take, say, a 3 months break if Easter is late in April, and they don't take any holiday between the 2nd of January and when Easter is, again, that's likely to be a 3 months break when they haven't taken any holiday pay, 3 months when there's been no unlawful deductions. So there is scope here for an employer who's faced with a swinging claim going back to actually look at the detail for that individual and see whether there is a point beyond which they can't go back. Now, the government has actually also committed to introducing legislation on this, but it won't be effective until 1st of July this year. What it is intended to do is to limit these backdated claims to a maximum in any event of 2 years. So, putting all of that into the melting pot, it seems that John Lewis may well have overreacted to the Locke case and have paid well over the odds. But the one good thing you can say is that their workers can truly say that they've never been knowingly undersold.
That's about the best joke we've got, so thanks for laughing. Right, you can remove the wet towels now. We're still sticking with the working time regulations, and the next case had to deal with quite a grim issue. What happens to accrued but untaken holiday entitlement if a worker dies in your employment?
Actually, it's one which caused us some consternation. You'll see why. It's a German case, but pronunciation is a bit challenging. And actually, I'm going to hand over to Andrew at this point.
Oh, thanks. Right. The case is bollock, class, and cock. If you don't mind, I'm going to follow Marie's lead, and I'm just going to call the employee Mr. B, because I don't think you want me saying that word for the next 3 minutes, really, do you? But Mr. B, he began to work for Class and Cock in 1998, but his health deteriorated. They truly worked him very, very hard indeed. In 2009, he took 8 months sickness absence, and then the following year, he again had extended series of sickness absence, and unfortunately, he died. He died leaving his wife as his sole beneficiary, and she contacted the company saying that the company owed the estate pay in relation to leave that her husband hadn't taken because he'd been working so hard. And she referred specifically to a customary practice that the company had of allowing employees to carry over holiday if they were unable to take that holiday because of pressures of work.
And you might wonder why the employer was reluctant. Mrs. B, I'll follow your example, had initially been complaining that the company hadn't been employing enough staff and that's why her husband had actually been unable to take his full holiday entitlement. He'd been made to work far too hard. And by the time of his death, he'd actually accrued more than 140 days of untaken holiday.
So it was going to cost them quite a lot. Well, you'll know that it's well established that where it's impossible for a worker to take holiday because the employment relationship has ended, then they're entitled to receive a payment in lieu. But the European directive, also precludes national laws or practice from providing that on termination, no payment of lieu of untaken holiday pay is to be paid to a worker where they've been on sick leave for the whole or part of the leave year.
So, again, European Court of Justice case, they decided that the worker's death didn't remove their right to a payment in lieu of untaken holiday, not really a surprise there. And equally, there's no need, in fact, for the estate to formally ask for those sums to be paid. It is a debt which is owed to them, and employers should be taking the initiative. So this case hit the employer where it hurts, Andrew. Finish our look at the working time regulations with a look at the definition of working time. So here it goes. Working time includes any period during which a worker is working at his employer's disposal and carrying out his activities or duties. This is one of our favourite cases. In Truelove and Scottish Ambulance Service, a Mr. Truelove and a Miss Wood were ambulance paramedics. Sometimes they were required to provide, and I'm only quoting, nightly relief cover at different ambulance stations, and during this on-call time they were obliged to stay at accommodation within a 3-mile radius of the relevant station.
Sorry. 2 employees,
Truelove, not what you think.
Truelove and Wood, and the employer's insisting that they stay in the same hotel providing relief cover.
Yeah, uncanny, isn't it?
Yeah.
But anyway, it's you've just got dirty minds, all of you. They had a target rather than an absolute requirement of responding to a call within 3 minutes, and the location of the stations meant that they couldn't stay at home.
Okay, well, the question on this was really quite simple. When they were at the accommodation on call, were they resting or were they working? And the Scottish Employment Tribunal had a very difficult task because there were contrasting precedents. European case law had established that on-call time is working time if it involves some form of confinement at a specific location, so the worker is obliged to remain at that location available for work. And that's the case even if the worker is allowed to sleep.
However, a worker is capable of being on a rest period where they're required to be contactable and in a position to respond promptly, but not at a specific location determined by the employer. Now here, the employer required the paramedics to spend time on call within a specified radius, but they weren't told specifically where that place needed to be. Now the tribunal felt that because the paramedics were not required to remain at a specific location determined by the employer, then not all of the on-call time should be regarded as working time, and time spent at the accommodation were considered by them to be rest periods for the purposes of the working time regulations.
So obviously the paramedics were dissatisfied with that and they appealed to the EAT. And the EAT said, well, actually, we think the tribunal has got that wrong because the paramedics were obliged to be present and to remain available at a place that was determined by the employer, albeit within a 3-mile radius. But because of that, they were constrained. They couldn't remain at home on call, and so they couldn't really say that the time was their own to enjoy.
And the next case looks at a similar issue, on-call working, but in the context of the minimum wage. Under the national minimum wage regulations, workers who are on call are deemed to be carrying out what's called time work and entitled to the minimum wage. But the regulations also provide for an exception to that rule where by arrangement a worker is provided with suitable facilities for sleeping at their place of work. Then they're only entitled to be paid for the time they're actually awake and working.
And I think, understandably, many employers took that to mean that there was no entitlement to minimum wage for hours spent sleeping. But it's important to remember that that exception only applies if the worker is sleeping at or near a place of work on call.
And this was demonstrated in this case of Whittlestone and BJP Home Support Limited. Mrs. Whittlestone was employed to provide care services to service users. She was paid £6.35 per hour under her contract for the time she actually spent giving care, so far so good at that time. She was also required, however, to undertake shifts from 11 p.m. to 7 a.m. They were called sleepovers. And this was to provide physical care for service users. She slept at their house. Notionally, she could be woken up to provide care at any point during a sleepover, but in practice, it actually rarely happened.
Brilliant job. Paid to sleep on the job.
Paid, but not very much. She was only paid a flat rate of £40 per week in respect of these sleepovers. And that was clearly below the minimum wage if all sleeping hours were taken into account, so she made a claim.
Well, the case got all the way again to the EAT, which decided that the entire sleepover shift was working time for the purposes of national minimum wage. There was an agreement in place that she would be present to give care during the whole of the sleepover shift, and if she wasn't, she'd have been disciplined.
So she wasn't truly on call as such, and the exception didn't apply. Whilst her activities during sleepover hours were limited, the judge put it this way: it wasn't as if she could slip out for fish and chips, or indeed curry and chips. So to treat the rest of her time as her own, that was just not possible. She was entitled to the minimum wage, as far as the judge was concerned, for the whole sleepover shift.
So obviously not a great decision for the care industry. And given the recent announcement of an increase in the maximum penalty for failing to comply with national minimum wage, which is going to go up from £5,000 to £20,000, and also the new policy of naming and shaming businesses that breach their obligations, this case triggered an immediate review and should do in your cases to make sure that your practices are compliant.
And talking about compliance type issues leads us to whistleblowing. And whistleblowing protection applies, as we've told you before, if somebody makes what's called a qualifying disclosure. That's got to be a disclosure of information by a worker who reasonably believes that the information tends to show that some form of malpractice has taken place. And it can include a health and safety issue.
But does that information have to be set out all in one go, or could it be spread out over a number of communications? And that was the question in Norbrook Laboratories and Shaw.
Now, Mr. Shaw, he was a sales and business communications manager. His team that he managed actually had to drive to customers on a daily basis, and in 2010 there was that horrible snowy winter, part of it anyway, and his team were finding it difficult. They raised their concerns with him, he raised their concerns with his manager.
And he then emailed the employer's health and safety manager asking if there was a policy on travelling in severe weather conditions, and also asking whether risk assessments had been carried out, which of course they hadn't been. Then he emailed the health and safety manager again and asked for some formal guidance, because the pressure was on his team to continue to drive in what he thought were dangerous conditions. And a week later he then emailed the HR department asking what the implications on his team's pay would be if they were unable to drive in the snowy conditions. And he insisted on a policy statement because he said that he had a duty of care for his team's health and safety.
At which point he got sacked. And he brought a claim for dismissal on the basis of being a whistleblower. And the first thing that the tribunal had to consider was whether actually he had made what's called a disclosure of information, which showed that somebody's health and safety was endangered. It's got to be a disclosure of information, not just an expression of opinion.
Well, it was decided that although if you looked at the emails individually, they probably wouldn't have amounted to disclosures of information, when you took them as a whole, they could be classed as a protected disclosure, a whistleblow, and so his claim could go forward. And in particular, the HR manager was aware of the 2 previous emails that had been sent to the health and safety manager. And his email to her made reference to both of the earlier ones. So if you took them as a whole, it was clear that the HR manager could have been in no doubt that the emails were communicating information about the danger of driving conditions and the risks to his team.
So you'll appreciate that the person who's made protected disclosures can't be dismissed for it. It's also the case that they can't be subjected to a detriment as a result of it. Now this leads us on to what Andrew has called Heartsink Employee of the Year. In Black Bay Ventures Limited and Chemistry and Gare, Mrs. Gare was employed as a pharmacist at one of the depots owned by Chemistry. They were an online mail order pharmacy. It would be difficult to say that she'd made a meaningful contribution by the time she was dismissed because she'd only been there 11 days.
So why Heartsink? Well, 2 days after starting at the depot, she emailed the pharmacist manager, copying in the HR manager, copying in one of the directors. But in that email, she raised health and safety concerns about monitoring of refrigerator temperatures, the absence of template stock checks for controlled drugs, the absence of fire alarms, and bizarrely, the absence of high chairs for staff.
Yes. 5 days later, the pharmacist manager sent all the pharmacists an email setting out a new standard operating procedure, coincidence I'm sure, which also dealt with the points raised by Mrs. Gare. However, she responded, copying her reply widely to staff and actually blind copying in the standards inspector, still saying that in a number of ways the new procedure failed to comply with statutory requirements. So back to the pharmacist manager.
Well, this is really where the wheels came off, because then she raised concerns that medicines were leaving the depot without supervision of a pharmacist. She was complaining about the fact that a request for time off in lieu had been refused. She'd been asked to change her working hours and she'd refused that, so she complained about that as well. And her employer had also been asking for her mobile number and she'd flatly refused to give that out.
In the end, she sent an email to the pharmacist manager, again circulating it to everybody else, complaining about all these matters, but now accusing the manager of discrimination, prejudice and bullying on top. Chemistry decided that that email was what they considered to be irrational and aggressive, and they dismissed her on the basis of breakdown of mutual trust and confidence and unsuitability.
But she argued that she'd been dismissed for making protected disclosures. And the Employment Tribunal was satisfied that the disclosures about health and safety and the standard operating procedures not meeting statutory requirements were protected disclosures. And it also found that it was clear that the employer resented her questioning its practices and procedures, and that that was the main reason for her dismissal, rather than poor working relationships with colleagues and management. And because of that, her dismissal was automatically unfair.
Of course, it may be that the company thought that as she'd only been there 11 days, she couldn't bring a claim. But you don't need to have 2 years for whistleblowing, so there are always exceptions. A phone call to check the position before they took their decision could have saved them a pretty penny.
Okay, well, let's move on. That case does highlight that there needs to be a causative link between the disclosure and the dismissal or the disadvantage that's been suffered by the employee. And the cooperative case, and Mr. Baddeley, I think demonstrates this quite well. We don't need to go through the facts because they're less relevant, but the main issue here was that a protected disclosure was made by Mr. Baddeley to his line manager. He was then subsequently dismissed for gross misconduct on a separate issue. And his line manager wasn't involved in that process at all. But Mr. Baddeley thought that the whistleblow had prompted his dismissal. But as his line manager had played no part in the disciplinary process, he hadn't had the opportunity to influence the outcome. And so because of that, Mr. Baddeley's claim failed.
So just a quick practical tip. If you have a situation where you've got an employee who's blown the whistle, but there are genuine, and I mean genuine, unconnected disciplinary issues that also need to be addressed, make sure you separate the two. You've got to be in a position to prove that whoever takes a decision on the discipline is not involved and wasn't even aware, if you can manage it, of the whistleblowing. But if you can't do that, then do tread very, very carefully. Right,
and the last part of this talk, a quick look at family-friendly rights. You're probably aware of the concept of emergency dependent leave, and that's where an employee can take a reasonable amount of time off work, unpaid, to assist with the care of a dependent in an emergency. But that also includes a situation where a dependent is giving birth. But to exercise the right, the employer has to be told of the reason for the absence and also outline the likely duration of the leave as soon as possible.
So we like to finish on a high. So this case is a heartwarming tale of a man who was needing to take his wife to hospital to give birth and was then dismissed.
Well, a few gaps to plug there. The fact that Mr. Ellis was already on a final written warning for attendance issues might tell you something about his work ethic. But he had taken his heavily pregnant wife to hospital several times one Monday, but he hadn't told his employer where he was going. Although, in fairness, I think his father did telephone for him later on in the afternoon. The next day, he took his wife back to hospital again, where she did give birth. But once again, he didn't bother telephoning his employer at all. In the end, they were trying to contact him and were leaving voice messages for him. Eventually, he got around to contacting his employer, again leaving a voice message for them, saying that he wasn't going to be in the following day either, but he still didn't explain why. Might not surprise you that he was called to a disciplinary hearing, obviously. And at that, he said, "Oh, I'm sorry I didn't manage to phone you sooner, but the battery on my mobile phone died." Convenient. He also said that he couldn't actually remember what his employer's phone number was, so he was dismissed.
But he still had the nerve to claim automatically unfair dismissal because of taking emergency dependent leave, taking his wife to hospital. But you'll be pleased to know that he lost at every stage. That protection didn't kick in because he hadn't kept his employer properly informed about the reasons for his absence. So he lost, thank goodness.